and welcome to Unacademy. Welcome to Polity Project 2.0. Today's topic, Collegium versus NJAC. Is it a choice between bad and worse? Let's find out. But first up, Constitution talks about that there shall be a Supreme Court of India consisting of Chief Justice of India and not more than 7 judges. This was the position of the Constitution when it was enacted in 1950. Can we increase the number of judges? Yes. How? Parliament has to enact a law, and through that law, we can increase the number of judges to the Supreme Court. And right now, we have a Chief Justice of India and 33 other judges. But listen to me carefully.
Sorry to interrupt your learning experience, for I have an important update for you. To celebrate the 10th anniversary of Unacademy, Unacademy has slashed the subscription fee by 50%. Plus, double validity. If you subscribe to our UPSC courses for 6 months, you get 6 months as an add-on, free. Ditto for 9 months as well as 12 months. Plus, Unacademy Assure. If somehow you do not manage to crack the civil services examination, then next year is free for you, unlimited access to our courses. To subscribe to Unacademy UPSC courses, use this code IAS English and you will unlock the lowest subscription fee. Let's crack it.
This law is not a constitutional amendment act, which means if you have to increase the number of judges to the Supreme Court, for that you don't have to amend the Constitution using Article 368. Parliament will have to pass an ordinary law by simple majority to increase the number of judges to the Supreme Court. But how are these judges appointed? For that, let's look at what did the original Constitution say. Original Constitution said every judge of the Supreme Court shall be appointed by the President. But how? After consulting such of the judges of the Supreme Court and High Court as the President may deem necessary. And once this judge is appointed, this judge will remain in office till he or she attains the age of 65. But listen to me carefully. Constitution says, for example, a Chief Justice of India is to be appointed. Who will appoint the Chief Justice of India? The President of India. Is the President bound to consult somebody? Such of the judges of the Supreme Court and High Court as the President may deem it necessary. Which means the plain reading of the Constitution tells us President may appoint anyone as the Chief Justice of India without consulting anybody, because the President may say, I did not deem it necessary to consult anybody, and this person is the Chief Justice of India. But if a judge other than the Chief Justice of India is to be appointed, Chief Justice of India shall always be consulted. Look at the phrase used, shall always be consulted. Long story short, every judge of the Supreme Court shall be appointed by the President, and the President shall have to always consult the Chief Justice of India. Consultation. Consultation is different from concurrence. What is the difference? For example, I'm consulting you. Am I going too fast? Should I slow down the pace of my lecture? If you say, yes, sir, you're going very fast, I may go faster because I'm only consulting you. That does not mean your consultation is binding on me. But if it is concurrence, I am asking you, am I going fast? You say, yes, sir, you have to slow down. I have to slow down. I shall slow down because your advice is binding on me. The plain reading of the Constitution tells us that deliberately the members in the Constituent Assembly use this word consultation and not concurrence. Because concurrence word, it's not that the members of the Constituent Assembly, they were not aware of such a word concurrence. They were. How? If you read Article 370 of the Constitution, there the word concurrence is required. Concurrence is mentioned. How? Constitution said Article 370 can be modified or deleted or abrogated by a presidential notification. But presidential notification requires concurrence of the Constituent Assembly of Jammu and Kashmir. So it's not that members of the Constituent Assembly, they were not aware of this word concurrence. They were. That is why at one point in Article 370, they used concurrence, but in Article 124, they used consultation, which means this consultation with the Chief Justice of India is not binding on the President of India, which means, long story short, the power to appoint judges to the Supreme Court is the prerogative of the executive. Nevertheless, there was a convention. And what was the convention? The convention was that the senior most judge of the Supreme Court was always appointed as the Chief Justice of India. Senior most in terms of not age, experience. So, what does that mean? Let's assume for a while that my age is 60, which is not my age, by the way, just making you explain. My age is 60, your age is 62. So, who is senior? You, in terms of age. But I was appointed to Supreme Court in 2020, and you were appointed to Supreme Court in 2022. Which means, in terms of seniority, I am more senior than you, despite the fact that if it comes to age, you are senior to me. But in terms of my stint at the Supreme Court, I am senior than you, which means I am the senior most judge of the Supreme Court. I may be appointed as the Chief Justice of India by the President. This was the convention that we were following. And in fact, every appointment to the Supreme Court or even high courts in the states, Chief Justice of India was always consulted and due respect was given to the views and the opinions of the Chief Justice of India. But things changed. 24th April 1973, in a landmark verdict, Keshavananda Bharati versus State of Kerala, a 13 judge bench of the Supreme Court invented a doctrine called basic structure, which limited the powers of the parliament in amending the constitution. The Supreme Court said, Parliament, you have the power to amend the constitution, save basic structure. Don't you dare touch the basic structure. Who was the Chief Justice of India? Justice Sikri. Justice Sikri retired. A new Chief Justice of India was to be appointed, and the convention of appointing the senior most judge of the Supreme Court as the Chief Justice of India was broken because the government of the day appointed Justice A.N. Rai as the Chief Justice of India. Because Justice A.N. Rai was at serial number 4 in terms of seniority. And what did the three other judges do? They resigned in protest. Why was Justice Rai picked up, handpicked by the government to be appointed as the Chief Justice of India? Maybe the government wanted to just fine tune or reverse the judgment of Keshavananda Bharati. Maybe overrule the judgment of Keshavananda Bharati, which A.N. Rai tried to do. But then that bench was dissolved, and Justice A.N. Rai, a black mark remained on his career. Basic structure doctrine survived. This is what happens when executive will try to plant their own men or women in the position of the Supreme Court and thereby disturb the independence of judiciary. Then in 1976 again, when the infamous judgment was delivered by a 5-judge bench of the Supreme Court in ADM Jabalpur case, Supreme Court said by the majority of 4:1, 4 judges said habeas corpus would be suspended during emergency. You can't approach the Supreme Court during emergency. There was only one judge who disagreed, dissented, Justice Khanna. Justice Khanna was next in line to become the Chief Justice of India because of his seniority. But he was overlooked, and Justice Beg was appointed as the Chief Justice of India. And what Justice Khanna did? Resigned in protest, just like the 3 other judges did previously. Long story short, till here, executive has primacy in judicial appointments. Matter went to the court. The year was 1981, S.P. Gupta v. Union of India, also known as the first judge's case. Listen to me carefully. At a high court, an important case is being heard by judges. And these judges are independent. Independent in the sense they will not bow down to the wishes and the aspirations of the executive. They will not bow down to the whims and the fancies of the executive. Executive can get these judges transferred to another high court and replace them with those judges who may toe the line of the executive. Don't you think it compromises the independence of judiciary? For God's sake, the biggest litigant is the executive, is the Union of India. And if the cases are filed against Union of India, and in the Supreme Court there are judges who are dominated by the executive, who are in cahoots with the executive, who are towing in the line of the executive, get justice. The principal question before the first judge's case was, number one, is the word consultation, which occurs in the Constitution, does it mean concurrence? If the Chief Justice of India says, no, this judge should not be appointed, is it binding on the executive? Number one. Number two, can the judges of the courts, high courts, be transferred without the consultation with the Chief Justice of India at the whims and the fancies of the executive? Because I told you previously, the Chief Justice's views, opinions were given primacy, respect. For example, in 1980s, one lady advocate was to be recommended by the executive that we will appoint her as the judge of the High Court of Delhi. The Chief Justice of India, Justice Chandrachud, was consulted. Chief Justice of India, in his opinion, because he was consulted, he said, don't appoint. Why? Because she is 42 and she is too young to be appointed as the judge of the court. Ironically, Justice Chandrachud, he was the lawyer at the Bombay High Court. And then he was appointed as the judge of the Bombay High Court. You know what his age was? 40. So a man at the age of 40 maybe is too old to be appointed, and a woman at the age of 40 is too young to be appointed. At the age of 40, Justice Chandrachud, Advocate Chandrachud, can become Justice Chandrachud because I may have been delayed in my appointment. I should have been appointed much earlier. But for a woman, 42 is too young to be appointed. But long story short, the position here is that views, considerations, consultations with the Chief Justice of India were always respected by the government. And here the position before the court was, Supreme Court said, number one, consultation does not mean concurrence, which means who has the final say in judicial appointments? Executive. Can the judges of the high courts be transferred against their will? If a judge does not want to get transferred, can you be forced out of that high court and transferred to another high court? Yes. Who has that power? Executive. This is how the position continued till we reached 1993. Supreme Court advocates on Records Association v. Union of India, also known as the second judge's case. Supreme Court reversed its original position. Supreme Court said, listen to me carefully, appointment of judges is a consultative, participatory, integrative process to select the best possible talent to the judiciary. So if you have to consult Chief Justice of India, Chief Justice of India is not an individual. Chief Justice of India is an institution. So you don't have to consult Chief Justice of India as an individual. You have to consult plurality of judges. Plurality of judges means more than one judge, more than Chief Justice of India. You have to consult Chief Justice of India and two senior most judges of the Supreme Court. Whatever they recommend, that's binding on you. This is what led to the emergence of Collegium System of judicial appointments. Collegium means Chief Justice of India and two senior judges of the Supreme Court. They will recommend names to the president. The president has no other option but to appoint. This is how the appointment of judges, this power was snatched by judiciary from the executive. Then it became known as, in India, judges are appointed by government. Didn't like it. The government asked the President of India, President, could you please consult the Supreme Court under Article 143? That is what we call presidential reference. That's what happened this year as well. A two-judge bench of the Supreme Court in April 2025 imposed timelines on the governor. That within this timeline, you have to give assent to the bills passed by the state legislature. The government of the day did not agree and asked the President of India, President Murmu, to send a presidential reference to the Supreme Court, seek the opinion of the Supreme Court on this matter. That's exactly what the government then did in 1998. Justice J.S. Verma was the Chief Justice of India. Mr. K.R. Narayanan was the President of India. Presidential reference was sent. And that is why this case is known as RE, which means presidential reference regarding appointment of judges. This was known as the third judge's case. Supreme Court further cemented the collegium system. Supreme Court said, now in order to be appointed as the judge of the Supreme Court, the president will have to consult Chief Justice of India and four senior most judges of the Supreme Court. And here also, listen to me. If these four senior most judges say Sarmad should be appointed as the judge of the Supreme Court, but the Chief Justice of India says no, my name cannot be sent to president for appointment because Chief Justice of India then enjoys veto. Any name not acceptable to the Chief Justice of India cannot be sent to the president for appointment. But alternatively, if two or more judges do not agree, if, for example, Chief Justice of India and two other judges, they agreed with my name, but two other judges, they did not agree with my name cannot be sent to president for appointment because there has to be some consensus within this collegium. Long story short, first judge's case, executive has the primacy in judicial appointment. Second judge's case, this power now shifts with the judiciary, with the Supreme Court. Third judge's case, further cemented this collegium system. Now the president will have to consult Chief Justice of India, four senior judges of the Supreme. The president may send the name back. Would you please reconsider this name which you have recommended? But if the same name is sent again, it is binding on the president to appoint that individual. Obviously, the government of the day did not like it. Fast forward, the year was 2014. Mr. Modi had been just sworn in as the Prime Minister of India. 99th Constitutional Amendment Act was passed. NJAC was in National Judicial Appointments Commission. Instead of collegium recommending names to the judiciary, to the president, let's have NJAC recommending names to the president. And let this body be, its composition should be diverse. It will have Chief Justice of India as the chairman. It will have next two senior most judges of the Supreme Court as the members. It will also have a law minister, union law and justice minister. It will also have two eminent persons. And these two eminent persons would not be chosen by the executive. These two eminent persons would be chosen by a committee which will have Chief Justice of India, which means judiciary. We'll have the Prime Minister of India as the member, which means executive. We'll have the leader of the opposition in the Lok Sabha, which means legislature. So legislature, executive, judiciary will come together and select two eminent persons who then will recommend to the president who is going to be appointed as the judge of the Supreme Court. This was considered a better solution because judiciary is represented, executive is represented, civil society is represented in the form of two eminent persons. Matter went to the court. The very next year, known as the fourth judge's case, 2015. The petitioner was Supreme Court Advocates on Records Association. The same petitioner in the second judge's case, Supreme Court by the majority of 4:1 struck down NJAC. Supreme Court said NJAC is unconstitutional. Why is it unconstitutional? Two reasons were given. The first reason was NJAC violates independence of judiciary, which is part of the basic structure. Second, NJAC violates primacy of judges in these judicial appointments, which is also part of the basic structure. Primacy of judges, because in the collegium system, any name not acceptable to Chief Justice of India cannot be sent to President for appointment because the Chief Justice of India enjoys veto. But with NJAC, if two or more members of NJAC do not agree with a name, that name cannot be sent to President for appointment, which means everybody may agree with my name, but not the Chief Justice of India, my name would still be sent to President for appointment, which means Chief Justice of India will lose the veto which he had. This, the Supreme Court said, is part of the basic structure. Since the primacy of judiciary is violated, NJAC is unconstitutional. Now, let's come to the most important part. Let's first praise the Collegium System. Then let's criticize the Collegium System and praise NJAC. And then see whether the choice is between bad and worse. Those who favor Collegium System, they say, what did Collegium System change? Even before, the Chief Justice of India, when he was consulted for appointment of judges to the Supreme Court, the value, respect was given to the opinion of the Chief Justice of India. And same would happen now as well. Collegium will recommend names to the president. If the president does not agree, the name can be sent back with proper details, which means you have to tell us in written why you don't agree with this name. Maybe we will reconsider. If we will reconsider, we will drop that name. If we will reconsider, but then still insist that this person should be appointed, it's binding on you. So the power that we have, the primacy that we have, is only when there is a stalemate. Otherwise, collegium recommending names, president accepting the names, that means it's a consultative process. The only place where the judiciary has an upper hand is when there's a stalemate, where the president says, I don't agree with this name, collegium says, I agree with this name, we agree with this name. It's only in this peculiar situation that primacy of judges plays an important role. The upper hand is with the judiciary. Otherwise, nothing changes. Even before collegium, the views of the Supreme Court Chief Justice was given primacy. Plus, if the biggest litigant is the union government, against whom the highest number of cases are filed, and which files the highest number of cases, is unfathomable how we can give power to appoint judges to this union, because then it would violate independence of judiciary, which is part of the basic structure. That is why, to ensure independence of judiciary, the first and the final word has to be with the judiciary. Otherwise, we would see a repeat of what happened in 1973, what happened in 1976. Executive should never be allowed to control the most important institution, which is the judiciary. Justice Verma, who I told you he was the Chief Justice of India when this presidential reference was heard in 1998, Justice Verma said, collegium system would lead to reduction in judicial vacancies. So the Chief Justice said, previously, executive was initiating the process of filling vacancies. There are vacancies in high courts. There are vacancies in the Supreme Court. Who will initiate the process to fill these vacancies and appoint judges? Executive. Executive then will consult the Chief Justice of India, and these vacancies would then be filled. But maybe executive deliberately does not want to fill these vacancies, because if the vacancies are not filled, pendency of the cases will increase. Maybe these cases which are pending involves the members of the political class, so they deliberately want vacancies in judiciary so that the cases go on delayed. Now, who will initiate the process of filling this vacancy? Supreme Court, high courts in the states. So if there is a vacancy in a high court, the Chief Justice of that high court will initiate the process and send names to the Supreme Court Collegium at the center. And then Supreme Court Collegium will forward these names to the president. That's how we will be able to fill these vacancies. And this reduction would happen in vacancy. Those who were in favor of NJAC, they said this process of appointment of judges should not be given entirely to the judiciary. But the supporters of the collegium system say, what is NJAC? The mere presence of law minister violates independence of judiciary. We don't need law minister because he's part of the executive. And you are saying two eminent persons would be appointed. Is our civil society so mature that we can have two members from the civil society who will then be part of recommending names to the Supreme Court? What do they know about the judiciary? We are the ones, the judges. We are the ones who know about judiciary, and we are best suited to recommend names to the president. We cannot share this process of appointment with the civil society because in India, the organic development of civil society has, as of now, not yet sufficiently evolved. But then look at this phrase, independence of judiciary. What does this independence of judiciary mean? If I'm a judge, I should be able to decide cases without interference from executive and legislature. Executive is separate, legislature is separate, judiciary is separate. When judiciary is deciding cases, I should not be influenced by the other organs of the state. I should be isolated, insulated from the other organs. That's independence of judiciary. That's not the only definition of independence of judiciary. Former Chief Justice of India, Justice Chandrachud, he said, independence of judiciary would also mean that I should be able to decide this case without succumbing to the pressures of the media. There is a trial by media. This lady killed Sushant Singh Rajput, despite the fact that the evidence was in the contrary. So, if the judges get influenced by what is happening in the media, where the chief priest of the nation at 9 o'clock would proclaim anyone as the guilty, how will judiciary be able to discharge its duties? That's independence of judiciary. Independence of judiciary does not only mean that I should be insulated from executive and the legislature. I should be insulated from the media as well, from the public opinion as well. I should be able to decide cases without interference or without succumbing to the pressures of the media and the civil society or the public opinion. And third important, independence of judiciary. Let's assume, although I'm not, let's assume I'm homophobic. I hate members of LGBTQ community. For example, I don't hate. Let's assume. But if a case involving their dignity comes to me, I have a personal bias. I hate them. But this personal bias should not dictate my verdict. I should be insulated from my personal bias as well. That's independence of judiciary. And this independence of judiciary has to be strengthened. Do you think the members of the Constituent Assembly they were not aware of it? Dr. Ambedkar was said that the most important office under the Constitution is the office of the CAG, Comptroller and the Auditor General of India. And the second most important office is the Judge of the Supreme. And that's why Constituent Assembly debated a lot on how can we give independence to the judiciary. And there are so many provisions in the Constitution which enhance independence of judiciary. You want to know these provisions? Number one, judges don't hold office during the pleasure of the president. They hold office till a retirement age. 65 for a Supreme Court judge, 62 for a High Court judge. So it's not that judges will be appointed and if they don't toe your line, you can remove them based on the whims and the fancies of the executive. No, they hold office till they attain a retirement age. That's to ensure independence. Their salaries, allowances, even pensions are charged on the Consolidated Fund of India, not subject to the vote of the parliament. You can discuss anything in the parliament except the conduct of judges. You can't discuss them, otherwise, you're violating their independence. Imagine parliament is discussing the conduct of a judge. Don't you think that will influence the judge from giving a different verdict? You are expressly barred from discussing the conduct of judges inside the parliament or the state legislatures, except, of course, if you want to remove that judge. For example, Justice Yashwant Verma may become the first judge of a high court to be removed from his office. There will be discussion in the parliament regarding his conduct because we are trying to remove you. Only in that scenario can you discuss the conduct of judges. Otherwise, you are expressly barred. The judiciary has been given the power to punish people for contempt. Now, you tell me, did NJAC snatch all these provisions? Did NJAC say that now judges will hold office during the pleasure of the president? that judges, their conduct will be discussed in the parliament, that their salary will be expenditure made on the consolidated fund of India and not expenditure charged? Did NJAC say that from now onwards, president will remove the judge at any time? Provisions which ensure independence of judiciary continued even after NJAC. So how did NJAC violate independence of judiciary, which the Supreme Court says is part of the basic structure of the Constitution? Perhaps judicial independence was of much value to the Constituent Assembly, much value. Even then, they said appointment will be done by the executive, removal will be done by the executive based on the resolution of the legislature, which means judges will be appointed by president, judges will be removed by the president, but not on her own. Judges will be removed by the president based on the resolution passed by both houses of the Indian parliament, that too by special majority. Why was this given? This was to ensure checks and balances. Otherwise, these are the provisions which will enhance, ensure independence. But appointment and removal, we cannot give it to judiciary because then there is no checks and balances on the judiciary. But perhaps the most scathing criticism of Collegium came from Supreme Court itself. A two-judge bench of the Supreme Court in Suraj India Trust 2010 asked pointed questions to the Chief Justice of India. Till date, these questions have not been answered. What are these questions? Will the two decisions of this court, the second judge's case and third judge's case, does it not amount to amending the constitution? Because constitution says judges shall be appointed by the president after consultation with such of the judges of the Supreme Court and High Court as the president may deem necessary for the purpose. Now you are saying based on collegium. Is there any collegium system mentioned in the constitution? Don't you think, dear Supreme Court Chief Justice, that constitution can be amended only by parliament, that too by invoking article 368? Or do you think that the parliament may not, but the judiciary for a judicial verdict may amount to amending the constitution? In the constitutional schemes, can the judges be appointed by discussions and consensus between judiciary and executive? Or can judiciary alone make the appointments? You seem to be doing exactly that. Does the word consultation mean concurrence, as it occurs under Article 224, appointment of High Court judges? There also you are saying consultation means concurrence. But the most important point, Supreme Court Chief Justice was asked, because of your verdicts, because of our verdicts, we seem to have made some of the words mentioned in the Constitution redundant. Redundant in the sense, Constitution says while appointing judges to the high courts, the president shall consult governor of that state as well. Now, in the entire process of appointing judges, governor has no role. Are you not then making some of the words mentioned in the Constitution redundant? Now, listen to me carefully. Constitution says the president shall appoint judges after consultation with such of the judges of the Supreme Court as well as High Court as he may deem necessary. But now Collegium says consult only us, Supreme Court judges, not High Court judges. Consult only us, which means Chief Justice and four senior judges of the Supreme Court. What about junior judges? Junior judges are not to be consulted, are not meant to be consulted. So you're making some of the words mentioned in the Constitution redundant. These questions have still not been answered, despite the fact that more than 25 years have passed. Nevertheless, NJAC, one solution, Collegium, one option. Those who say Collegium system is better, we have given the reasons. Those who oppose the collegium system, they say this entire process lacks transparency. It is like nepotism in judiciary, where judges are appointed by the Supreme Court Collegium, recommending the president. And these individuals who are recommended, they are sons, daughters of judges and lawyers. There is nepotism in judiciary. Those who praise NJAC, they say this is the best possible solution that we can have. Others say, despite collegium, executive still has the final say. It's a myth that in India judges are appointed by themselves. That doesn't happen. It's still executive who is appointing despite collegium. How? Supreme Court advocate, senior advocate, Gopal Subramaniam. He was recommended by Supreme Court Collegium to the president, appoint him as the judge of the Supreme. And if he would have been appointed at that time, over a period of time, he could have become the Chief Justice of India as well. In terms of seniority, he had age by his side. He was not appointed. Perhaps the reason was because in the Gujarat riots case, he was the amicus curiae. Who has the final say? Executive. Mr. Saurabh Kirpal, an advocate of the Delhi High Court, was recommended by the Supreme Court Collegium that appoint him as the judge of the Delhi High Court. He was not appointed. And for the first time, we got to know the reason. Because you have to give a written reply, written advice back why you are not accepting this name. The government said Mr. Saurabh Kirpal is openly gay and his partner is a Swiss national. The Supreme Court shot back. The Collegium replied, no, we insist. We reiterate his name. So what? He is openly gay. Homosexuality is not a crime. We have decriminalized homosexuality in Navte Johar v. Union of India 2018. So what? His partner is a Swiss national. Switzerland is not an enemy country. Despite reiterating this name, what did I tell you? Collegium system, second judge's case, third judge's case said, if a name is sent by collegium to president, it's binding on the president. President may ask for reconsideration of that name. But if the same name is reiterated again, it's binding on the president. Same name of Saurabh Kirpal was reiterated, yet he is not appointed. Who has the final say? Executive. Now contrast this with Justice Pancholi, initially of the Gujarat High Court, then transferred to the Patna High Court, then recommended to the Supreme Court. There were serious reservations raised against him by Justice Nagaratna, who is part of the collegium. Yet his name was recommended. The president appointed him in no time. So it seems like executive can cherry pick. Cherry pick in the sense, collegium is recommending 3 names or 4 names. President is appointing 2 of them and keeping the 2 other pending. So who decides the appointment of judges? Executive. So this myth needs to be broken that judges are appointing themselves in India. No, executive still has the final say. So now you have heard 3 extremes. Collegium system, which means judges appointing themselves. NJAC, which means a beautiful system where judiciary, executive, legislature, civil society together collaborate with each other in recommending names to the judiciary. And then another extreme that it is, despite collegium, executive is appointing themselves. As executive is appointing judges. Maybe something we have in South Africa, which is an independent judicial commission. Something we have in UK, which is an independent judicial commission. That is what is needed in. And those who favor collegium, there are shortcomings in collegium. Those who favor NJAC, there are shortcomings in NJAC. So possibly the choice between NJAC and collegium is a choice between bad and worse. Let's look at some of the PYQs. The power to increase the number of judges in the Supreme Court of India is vested in Parliament. What is the provision to safeguard autonomy of the Supreme Court of India? While appointing the Supreme Court judges, the President of India has to consult the Chief Justice of India. The Supreme Court judges can be removed only by the Chief Justice of India. No, can be removed by the President based on the recommendations based on the resolution passed by both houses of the Indian Parliament by special majority. The salaries of the judges are charged on the Consolidated Fund of India, to which legislature does not have the right to vote. All appointments of officers and staff of Supreme Court of India are made by government? No, are made by Chief Justice of India by the judiciary. So 1 and 3 is correct. A is the right answer. What do you think of this tussle between the government and the judiciary when it comes to judicial appointments? And what is the best solution in appointing judges to the superior judiciary? Do let me know in the comment section. I will see you again tomorrow, 6 o'clock in the evening. Till then, have a great time.